According to a recent report by the National Employment Law Project, roughly 17 million FBI background checks were conducted for employment and licensing purposes in 2012. This is a six-fold increase compared to checks conducted just a decade ago. Why this increase, and what does it mean for job seekers and employees? My guest is Ossai Miazad. She is partner and co-chair of the Discrimination and Retaliation Practice Group, the employment law firm of Outten Golden in Manhattan. Ossai, it's a great pleasure. Thanks for joining us today. How prevalent is criminal background check screening these days?
Well, it's very prevalent, and it's increasingly so. Approximately 80% of employers are reporting that they're using some form of criminal background check. So it is imperative that employers get it right, that the credit reporting agencies that they're using to report out the information is held accountable, and of course that employees or applicants understand what their rights are. These background checks run across industries, that run across the kinds of jobs and job duties that applicants have, and so it's very widespread.
Ossai, is this increase a result of regulations requiring background check screening, or are employers just doing this on their own?
By and large, employers are actually choosing to do them on their own. There are industries where they're required. For example, jobs that involve caring for children or the elderly or individuals with disabilities, or you'll see the requirements in the for federal employees or applicants who are applying for jobs in the financial industry. But by and large, employers are increasingly using these criminal background checks to make hiring decisions voluntarily.
So most employers are not required to conduct criminal background checks, but are they in some cases prohibited from doing so prior to hiring an employee?
They're not prohibited from using a criminal background check to make a hiring decision. That said, there are federal and local regulations that restrict the ways in which these background checks are used, and it is important that if an employer decides that they are going to actually make a hiring decision based on an applicant's criminal background history, or to take action against a current employee because of their criminal background history, that they make sure that the information that they're getting is reliable, that they consider other factors, for example, any evidence of rehabilitation, that they narrowly tailor whatever screen they're using so that it is job related. So while it's not prohibited, there are many rules and regulations that an employer must consider and follow when they're deciding to deny an applicant, for example, a job based on their criminal history.
And Ossai, your firm has filed several class action lawsuits on behalf of African American and Latino job applicants.
Sure. African Americans and Latinos, the unfortunate reality is that they are disproportionately impacted by the criminal justice system in the U.S. What that means is that they are more likely to face arrest and convictions, and disproportionate to their representation in the general population. And so when you use a criminal background check screen, even if you're applying that to all of your applicants, that still may have, and probably does have, an adverse impact on African American and Latino applicants. For this reason, the U.S. Equal Employment Opportunity Commission has issued regulations that give guidance to employers on how they should be administering their screens. Those regulations require that the employer take into consideration the nature and the severity of the criminal history record, the time since the conviction, and also to make sure that the criminal convictions that they are considering are in fact job related. It really, in essence, what's required is an individualized review of each applicant, and conversely, blanket prohibitions are violative of Title VII because they don't allow for individualized review. They're saying, anyone with a felony conviction, no matter what the circumstances, no matter how long ago, no matter what the history of rehabilitation, is not eligible. And based on national statistics, we know that that is going to have a disparate impact on minority communities.
So let's talk about the process. How does an employer actually obtain the criminal history information?
Typically, employers are using what's called credit reporting agencies, or CRAs. These credit reporting agencies, and there's hundreds of them out there now, collect information from a variety of sources. There's a lot of information out there that is publicly available through the web. They gather information from courthouses, from other sources that they can actually going to the courthouse and getting the information, and then they review and they compile the data and they produce it in a report to the employer. Another way that sort of at the earliest stage where an employer may find out about an applicant's criminal history is on the application. In most jurisdictions, an employer can ask whether an applicant has been convicted of a crime. And there are a few jurisdictions which actually ban that question, but by and large they can ask the question. And one thing that applicants should be very aware of when they see that question is to read it carefully, to make sure to answer the question truthfully, and that they should assume that if the question is on the application, that the employer is likely, very likely, to run a criminal background check, irrespective of what the answer is on that question. So it puts an applicant on notice that this is probably going to be part of the decision-making process. But it's not enough notice. If an employer decides that they're going to use a credit reporting agency and gather the criminal history information, then they're required to take certain steps, certainly before they make any sort of decision based on a decision not to hire based on the criminal history conviction. They have to provide the report to the applicant and give enough time for the applicant to correct any sorts of mistakes. As the NELP report highlights, unfortunately, while the information is being reported, the dispositions in a lot of cases are not being reported. And so what that means is you'll have someone who has an arrest for a felony and it's open. There's no disposition information, and that may very well have been dismissed. Another thing that may happen is that it may be that it's a sealed offense, and that still appears on the record. And so these are just some examples of the errors, and the NELP report does a good job of highlighting how frequent it is that there are mistakes in these criminal background checks that are costing workers jobs. So the employer is obligated to allow for some period of time for the applicant to understand that a decision is being made based on the criminal record, to correct any mistakes. And if the employer ultimately makes a decision based on the background check, then they're obligated to provide the information from the credit reporting agency, and again to let the applicant know that this was the reason why the decision was made, so that the applicant, especially in the situation where there's an error, can take steps to correct the mistake.
My guest has been Ossai Miazad, and you can see why she is partner and co-chair of the Discrimination and Retaliation Practice Group at the employment law firm of Outten Golden in Manhattan. Ossai, it's a great pleasure. Thanks again.
Thank you.
And you're watching the Employment Law Channel, an affiliate of the Legal Broadcast Network.